This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. Good morning. This is the January docket of the Tennessee Court of Criminal Appeals here in the middle section of Tennessee. My name is Robert Wiedemeyer. I live in Nashville. My colleagues today are Robert L. Holloway, Jr. From Columbia, Tennessee, and Timothy L. Easter from Williamson County, Tennessee. We have a two-day docket. This is a second case today, and we are very fortunate to have the assistance of the Administrative Office of the Courts and Mr. Jim Hivner and his staff, who have been able to negotiate the virtual world, so to speak, so that we can conduct our oral arguments via the Zoom method. This is our second, or for the middle section, this is our second Zoom docket. We would much prefer, of course, to be in the courtroom, but we're doing this in an effort to continue getting our cases decided and disposed of. So we're fortunate to be able to have oral arguments in the fashion we're about to. However, that just keep in mind, please, that we're trying to handle this exactly like we would in open court. In that regard, we have read the briefs for this case and all of the cases for this docket. Each side has 20 minutes to argue. If you represent the appellant and you wish to reserve part of that 20 minutes for rebuttal, let me know as you start your argument, and I'll help keep up with the time. And I think that covers everything that I have before we get started. Any preliminary matters, Mr. Hivner?
No, Your Honor.
All right, if you'll call the next case on the docket, please.
State of Tennessee versus Trenton Jermaine bail.
Morning, Your Honors, and may it please the court. My name is Kendall Stivers, and I'm an assistant public defender with the Appellate Division of the Public Defenders Conference. I represent Mr. Trenton Bell in this case, the appellate, on his appeal out of the Wilson County Circuit Court. Judge Wiedemeyer, I'd like to reserve 3 minutes for rebuttal, if you please.
Certainly.
Thank you, Judge. Your Honors, today we're asking this court to reverse the judgment of the trial court for two reasons. First, the trial court failed to provide a curative instruction at trial to the jury to disregard expert testimony that was tendered by a lay witness after the trial court had already found and ruled that the state needed to lay a foundation before the witness was able to proceed further with his testimony. Specifically, this related to the testimony about the accuracy of a timestamp on an exhibit and a note at trial that was in Mr. Bell's phone. It was probably the greatest piece of evidence of premeditation in this case. We're asking the court to review this under a plain error standard. Second, Mr. Bell's right to a fair and impartial jury under both the 6th and 14th Amendments was violated when the jury veneer did not represent a fair cross-section of the African-American community in Wilson County, which Mr. Bell identifies as. I know the court has read the briefs and is familiar with the record in this case, but I'd like to give a brief statement of the facts for the issues before I proceed into argument. Mr. Bell was convicted as indicted in this case after a jury trial. He was convicted of 3 offenses: first-degree premeditated murder, tampering with evidence, and abuse of a corpse. The narrative presented by the state at trial was that Mr. Bell choked or strangled his girlfriend after they had an argument, arranged her body in the bathtub to look as if she had overdosed, and then called 911 saying that she had in fact overdosed. The medical examiner testified at trial that the victim had no controlled substances in her system at all, however, and that she had died of asphyxiation and had hemorrhaging on the muscle that constricts a person's windpipes. Mr. Bell confessed later to a friend that night. His name was Mr. Boston. He also testified at trial And then Mr. Bell later confessed to police approximately 2 days, or approximately a day after the victim died, and told police that he did not mean to kill her and panicked. So the only real issue at trial was Mr. Bell's mens rea, with what mental state he did in fact kill the victim. There was some testimony at trial that he was a wrestler, and also that he perhaps had put her in a chokehold for too long, not intending to kill her. Now, the facts as to the first issue, Mr. Bell had a cell phone that he surrendered into the custody of the police when he was interrogated on February the 18th. Police dumped or extracted the information from the cell phone about 3 years later after they seized it, and I think less than a month before trial, and found a note on it that was entitled "Stickin' to It." It was very similar. The story contained within it was very similar to the initial overdose story, and a story about a fight that Mr. Bell had told the EMTs and had told the police initially.
Excuse
The
me.
note, yes, Judge.
Did that Zoom? Does a sneeze Zoom on Zoom? Because I apologize. I just sneezed. I zoomed to sneeze.
I didn't
Probably
hear
the
it.
first, Judge Wiedemeyer. I apologize.
I didn't hear it, but bless you.
I did not hear it either, and I think that's a very good response from counsel there.
Judge. The note that was found was time-stamped the day before Mr. Bell killed the victim. The timeline goes, the note was time-stamped February 16th, the 911 call and the struggle or the victim's death was on February 17th, and Mr. Bell's arrest and seizure of the phone was on February 18th. The note was actually physically entered. A picture of it was entered into evidence as Exhibits 12A, B, and C at trial. The officer who did the cell phone extraction testified at trial and started to explain on cross-examination how the time on cell phones worked, specifically Coordinated Universal Time or UTC time, which would display differently, as I gather from his testimony, than what we would be on in Central Time. He was not, however, qualified as an expert either in the Android operating system that Mr. Bell's phone used or UTC. This testimony, we argue, was not solicited by defense counsel on cross. He merely was inquiring about the accuracy of the timestamps on the phone, because the detective did admit during cross-examination that on another note that they found in his phone, the timestamp on that was stamped at a time when Mr. Bell did not have his phone, was interrogation. So it called into question the accuracy, at least on the face value of the timestamps.
Well, Mr. Stivers, let me ask you a question. So you're not disputing what the information that they recovered from the cell phone stated. You're disputing just the timestamp, right?
Yes, Your Honor.
From the timestamp, or at least from the facts of the case, we know that the phone was taken into the government's possession on 2/18/15, 2 days after or a day and a half, whatever the period of time is after the woman died.
Yes, Judge.
So the defendant's basic position is this timestamp or this information could have been placed on the defendant after the victim died?
You say that again, Judge.
Uh-oh. I think I'm frozen.
Yes, you are. We can hear you, Bobby.
You can hear me? I couldn't see anybody else. Did I complete the question, Ms. Stivers?
You did, but I didn't understand it and was asking you to
Okay.
repeat it. So.
What I'm saying is that we know that this information was on the phone before February the 18th, 2015, when the police seized the phone. And so the defendant is basically claiming that the state failed to prove that the information was on the phone before the victim died, correct?
Correct. At least the testimony that Detective Bringhurst, who is the detective that did the cell phone extraction, the testimony that he gave, he would not be able to pinpoint exactly when it was made. The cell phone could have been, the note could have been generated after the victim passed away.
All right. Doesn't that basically result in a jury question as to when the note was made based on, let's say, other circumstantial evidence in the case?
It could be. It calls into doubt the when the note was done or when the note was created. Now, there were other pieces of testimony and evidence that a jury could have taken to be premeditated, to indicate premeditation. I know there's an inference if there's concealment after the offense. And the medical examiner also testified that for a human in general, it would take approximately 4 to 6 minutes for someone to die of asphyxiation. But the note was the absolute most critical evidence of premeditation in this case. And
to me, I mean, it seems like the most important evidence that the jury consider as to premeditation was the fact that on the defendant's phone was a description of basically the way the woman died.
Correct. And that's why counsel at trial kind of had an aha moment after cross-examination. He didn't object to the testimony, but after the detective testified for a bit as to what we were arguing would have been expert testimony tendered by a lay witness, he did object. The trial court did say they would need to lay a foundation, but there was no curative instruction. And we're arguing that instruction would have been very critical for a jury, especially in light of Mr. Bell's confession that was played for the trial, saying that he didn't mean to do it and he had panicked. The note, particularly in light of the fact that the other testimony by Detective Bringhurst indicated that the timestamp exhibits 12 A, B, and C couldn't have been taken at the face value, would have been very significant in going toward premeditation and whether or not this was something that he had planned and detailed in that note before it happened on the 16th or something that he did afterward just to get his mind right.
So the timestamp would indicate that this note was created well before the killing?
Yes, Judge, the day before.
And the note itself just talks about her being in the bathtub. He's knocking on the door. The door was locked. Water started coming under the door, and she has suicidal tendencies. So based on that, you think a juror or trier of fact could infer premeditation?
Absolutely.
Because this was created sometime before the actual incident. Okay.
Yes, Your Honor.
But isn't that the story he initially told?
That is the story that almost tracks almost identically. So the jury question would be if that information from Detective Bringhurst was stricken, the jury consideration would be whether or not this was the act of somebody who was panicked afterward and trying to get his story straight, or whether or not this was something that was carefully planned. If the court has no further questions, I'll move to my second issue, which is the issue of jury selection. And I'll be clear on the outset, we are not alleging that anything malicious occurred by the Wilson County court system or the clerk's office, nor are we arguing that this court should prescribe any sort of system to ensure the constitutional right in the style of affirmative action. All we are arguing in this case is that under the test prescribed by the 6th and 14th Amendment to show that Mr. Bell was denied a fair and impartial jury, that he meets the criteria for those. The testimony at pre-trial hearing and during a jury out hearing at trial was by the circuit court clerk of Wilson County, and Madam Clerk testified about her office's procedures for selecting potential jurors. They draw names randomly from potential jurors that are in a thing called TNCIS, TNCIS, which is used by approximately 80%, she testified, of the clerk's offices in the state of Tennessee. So pretty much every county except for some of the metro areas. The veneer, according to the record, was composed of less than 1% African-American potential jurors. Mr. Bell is African-American, and Madam Clerk agreed that the population of the percentage of African-Americans that were in the potential veneer was not anywhere near what their proportionate number was for Wilson County.
Mrs. Stivers, let me ask you a mathematical question.
Yes,
I know your brief says 0.03%. Wasn't 3 out of 113 actually 2.655%, slightly less than 3%? It's not 0.03%. It's 0.03 or 3%.
Well, I don't know if I can do math on the spot. I know there were 3 that initially when they called everyone up, there were 3 out of 113 or 100.
Just drop it to 100. 3 out of 100 would be what percent?
3%.
Okay. I think that there's a mathematical error in your brief, but it's still substantially less than 7%, whatever the case is.
So there were 3 out of the jury panelists that were called and 0 out of the people that actually made it up toward that were actually questioned during the veneer. Now, the record doesn't indicate how they knew these individuals' races, but there's some discussion by the state and the court and defense counsel, but I don't know how they knew them. It didn't seem to be that they asked them on the record. So it is what it is.
Did the defendant use all of the preemptory challenges?
I don't believe so. I know my memory's fuzzy. I think there were between 8 and 12 that were used. But I can't testify to that. I can't give you an exact number.
Record will probably show that, I assume.
Yes, Judge. I apologize. But the jury selection, the system drew from Tennessee driver's license and identification cards for people that registered that they had residency in Williamson County. And Madam Clerk testified that her office did keep records of the racial composition and some of the other demographics of the people that were in the jury pool, but it seemed from the record that they did so after their service. And she did not indicate what kind of, if this was a survey or anything informal or formal that they did. She did indicate that, or did testify that African Americans had been underrepresented in the jury veneer for the past 3 pools, and which was approximately over the previous year. I don't know if they did their jury panels in quarters there or not, but she said it was approximately a year that they had been underrepresented. The trial court denied the motion on the basis that the procedure was the one that both the judge and Madam Clerk had used since they had been elected in 2014, and it had not been altered, and they had not stricken anybody for their racial composition. So the motion was denied on that basis. This standard of review, the right to a fair and impartial jury is considered a structural constitutional error that requires automatic reversal. The tests for the 6th Amendment and the 14th Amendment are quite similar. Mr. Bell needs to show this court that he is a member of an excluded group under the 6th Amendment, or an excluded group is a distinctive group in the community, which the case law that I included in my brief, African Americans do qualify, especially in Wilson County. The representation of the group in the jury pool is not fair and reasonable in relation to the number of group members in the community, which Madam Clerk testified it was not. And where the two prongs differ under the 6th and the 14th is that under the 6th, the underrepresentation is due to a systematic exclusion in the jury selection process. And under the 14th, it's that it has been underrepresented. That group has been underrepresented for a significant period of time, and the selection procedure was susceptible to abuse. Where it gets a little difficult in this case, we know that there was underrepresentation. We know that it had been a problem within a year, but there's not a whole lot in the record to show exactly how this is being abused, because this is on its face a neutral selection process. The numbers that we have provided with the court were all done through the record keeping of the Madam Clerk or the Circuit Court Clerk in Wilson County. The only thing that we can say without doubt is that the process is susceptible to providing underrepresentation, and under the guise of neutrality, it has resulted over a year's time, at least at the time of this trial, that anybody who was African American who had a trial in Wilson County may or may not have seen a face that was similar to theirs on their jury panel.
And jury. Is there authority to support a Sixth Amendment violation based on that kind of evidence?
The one that touches most closely on this is an old case from the United States Supreme Court called Norris versus Alabama. And in that case, the commissioner who was in charge of the jury selection process testified that no one was automatically and systematically excluded. No one was excluded on the basis of race or color. They didn't inquire as to a person's race. But the court did find in Norris that, and I'll just read from the case, if in the presence of such testimony as defendant adduced, the mere assertions by officials of their performance of duty were to be accepted as an adequate justification for the complete exclusion of African Americans from jury service, the constitutional provision adopted with special references to the protection would be but a vain and illusory requirement. So it's an admittedly difficult question, but we do argue that Mr. Bell meets the criteria that the tests show. I don't know. I guess it's kind of like Potter Stewart argued. In pornography, I can't put my finger on it, but I know it when I see it. And again, we're not alleging anything malicious occurred, but the system in being admirably neutral has resulted in tendencies to allow, in this case, Mr. Bell to be denied having an African American on the jury and underrepresentation in the jury veneer.
Miss Stivers, you're
Yes, Judge.
pretty much getting into your rebuttal time. If you want to wrap it up, you can still have a couple minutes for rebuttal.
I'll turn it over to Ms. Orr. Thank you.
All right. Thank you. General Orr, good morning.
Good morning, Your Honors, and may it please the court, Courtney Orr on behalf of the state. I'll just take the same issues the defendant has addressed in the same order, starting first with the testimony about the UTC time code. Simply put, the defendant has not shown that he is entitled to plain error relief for the court's failure to sua sponte strike testimony that the defendant elicited on cross-examination about the universal time code. And I do want to take just a moment to issue a point of clarification before we get too deep into this argument. That in his brief, and here again today, the defendant appears to conflate a challenge to testimony about the UTC time zone to an objection to any evidence about the notes found on his phone or any evidence to show that this note was created on February 16th, the day before the murder. The defendant's trial objection was narrowly tailored to testimony about the UTC time zone, and that is the narrow issue he raises before the court today. Objection to the UTC time zone testimony would not have excluded all evidence about this note and would not have excluded all evidence about the timestamp or the date on that note, and to suggest so would be disingenuous. Here, there are two different sources of evidence to show that the note was created on February 16th. First was introduced during the state's direct examination of Detective Binghurst, where police had done a physical search of this phone and taken photographs of the stick-and-to-it note as it appeared on the screen. On the face of the photograph, it shows that the note was dated February 16th, the day before the murder. Then, during cross-examination, the defendant introduced the Cellbrite data dump, which showed the date and timestamps of 3 notes written on the defendant's phone between February 16th and February 17th. 2 of those notes showed, based on the face of the timestamp, that the February 18th notes were created sometime that evening between 5 and 8 p.m. The defendant asked Detective Binghurst if he was aware that Mr. Bell was in custody at 5 and 8 p.m. on February 18th. Detective Binghurst said yes, at which point the defendant asked, so there's no way he could have made those notes. And then Detective Binghurst goes into his explanation that the timestamps on the Cellbrite data dump spreadsheet do not reflect on their face Wilson County local time. Instead, you had to subtract 6 hours from the face of the time stamps to figure out local time. The detective did not admit that the timestamps indicated that the defendant was in custody when these notes were made, as the defendant seems to have suggested today. So that being said, here, plain error review is simply not necessary for 4 reasons. First, no clear and unequivocal rule of law was broken, and the defendant's rights were not adversely affected, because Detective Binghurst's testimony regarding how to calculate local time from UTC time was elicited during the defendant's cross-examination. Foley v. State clearly says that the defendant cannot be heard to complain about allegedly incompetent evidence that was elicited during cross-examination, as he did here. So therefore, there is no clear and unequivocal rule of law that was broken for the court's failure to strike testimony that the defendant introduced. Second, the defendant could have raised this issue for tactical, or could have waived this issue for tactical reasons, It's evident from the record that the defendant was attempting to impeach the accuracy of these Cellbrite timestamps to suggest that the face of the timestamps indicate that 2 of the notes were created while he was in custody. However, his attempts to make that point before the jury were scuttled when Detective Binghurst explained that such an argument was based on an inaccurate assessment of the timestamps. As I've noted before, the defendant could not have struck testimony that he introduced on cross-examination. And to the extent that the state asked Detective Binghurst during redirect examination to further clarify UTC testimony, that testimony that he gave did not change or really further clarify any UTC testimony or how to calculate UTC time zone. And the defendant could have made a tactical decision not to object or not to move to strike the state's redirect questions in order not to call more attention to this failed attempt, just discredit the Cellbrite testimony.
Detective Binghurst explained why there was a 6-hour difference between this timestamp and the actual time.
He explained that UTC time is essentially Greenwich Meridian time.
Okay.
That it is, this is the universal time code that all digital devices use, and to adjust local time from that time code, you just basically have to figure out what time zone you're in from Greenwich Meridian time. And finally, consideration of this issue is not necessary to do substantial justice because, as I have already noted, outside of the Cellbrite data dump, there was additional evidence to show that the stick-and-to-it note was created on February 16th, the day before the murder, in the form of a photograph of the note taken during a manual search of the defendant's phone, in which the title page of the note and in the top right corner above the substance of the note, it shows that it was created on February 16th. And there is testimony to show that that date would be the date that it was created or the date that it was last modified. the jury could rely on the photos of the note to determine that the defendant wrote the note the day before the murder and to show premeditation. We submit that the defendant is not entitled to plain error relief for the court's failure to sua sponte strike testimony regarding universal time code. Unless there are any other questions about this issue. Next, the defendant has not established a prima facie case that the Wilson County jury selection system systematically excluded African Americans from jury veneers. Notably, the defendant here and at trial argues that Wilson County has 7.1% African American population, or has that at the time of the trial. However, there is absolutely no evidence in the record to show what Wilson County African American population would be. The only substance of the record showing the 7.1% statistic is statements of counsel in pleading and arguments of counsel at the hearing, which this court has repeatedly stated are not evidence. Further, in at least two opinions from this court, one as late as 2017, this court has held that statements of counsel regarding a certain population percentage for jury selection is not sufficient to show a prima facie case of systematic exclusion. Instead, the defendant bears the burden of introducing evidence of what that community's population within the county would be. Next, the defendant has not shown that the Texas system systematically excluded African Americans from the jury veneer. Veneermen in Wilson County are selected from a neutral list of driver's license and photos IDs, which is the same procedure which has been approved by the Tennessee Supreme Court. In order to show systematic exclusion, defendants must show that the system resulted in systematic exclusion of the group, and this court has been reluctant to find systematic exclusion based on disparity alone. Indeed, in Truesdale, this court said, relying on statistical underrepresentation would, quote, exalt racial proportionality over a neutral jury selection procedure. Statistical disparity will only show systematic exclusion if the disparity exists not in just select cases, but in consistent jury veneers over a period of years. Previously, the Tennessee Supreme Court has found systematic exclusion based on statistical disparity in cases where residents of the farm in Lewis County had been excluded from every single jury veneer over a period of 4 years. Here, the only evidence we have of statistical disparity is that the clerk testified that in 2 of the past 3 jury veneers that had been occurred over the past year, there had been a 5% or 6% representation of African Americans within that jury veneer. I want to pause a minute to note that I disagree somewhat with counsel's representation of the clerk's testimony regarding this issue. The record just shows that 2 of the past 3 veneers within the last year had these percentages. I do not believe the clerk's testimony can be read to say that those 3 veneers constitute all of the veneers for the past year. Instead, the only evidence we have is that in 2 recent veneers, there was a potential 1% disparity between the African American population within the veneer and counsel's stated African American population of Wilson County. Simply cherry picking 2 recent veneers is not enough to show systematic exclusion in this case. Instead, the defendant had to show systematic exclusion over a period of time, which could have been done by relying on the veneer reports, which are created by the clerk's office. The clerk testified that as veneermen report for duty, they noted a variety of demographic data, including race, and that is what was used to create the veneer reports. And the defendant relied on those same veneer reports for the 2 of the past 3 veneers that he presents to this court today. Simply put, the defendant failed to present a prima facie case that the Texas system systematically excluded African Americans from jury veneers. and therefore he is not entitled to relief for his claims of the 6th and 14th Amendment violation. Unless there are any further questions by this court, we will stand on our brief for the remaining issues, and we ask that you affirm the judgment of the trial court.
All right, thank you very much. Ms. Stivers, you can have your full 3 minutes for rebuttal.
Thank you, Judge Wiedemeyer. I'll just clarify some things briefly, because otherwise I'm just going to be rehashing my reply brief. I will clarify to General Orr's point. It should be noted we are not challenging that the note was admitted erroneously. The only thing that we are arguing is that Detective Bringhurst, there should have been a curative instruction that he was not to testify. He could not testify exactly as to when the note was recorded. The note was made under UTC if it was not the times the one that was reflected on the exhibit. Just that it needed under the line of questioning to remain called into question, the accuracy called into question. And as to whether or not this was elicited on cross-examination, I'll direct the court to my reply brief on pages 5 and 6 for a discussion of the cross-examination between defense counsel and Detective Bringhurst for the court to deduce whether or not it was in fact elicited. We would argue it wasn't. Defense counsel did not address UTC, just challenged the accuracy of the timestamp that was on it. And as to the testimony from the clerk, I would direct the court, if the court wants to see exactly what the Madam Clerk said about the population. It's in volume 5 on page 242. And the clerk said, defense counsel said, "Are you aware in the past, specifically with my motion with African Americans, how that percentage reflects in the prior jury polls?" And Madam Clerk said, "The last 3, the reflection was 1, I can't remember exactly, 1 was 6 point something and 1 was 5 point something." And defense counsel said, "But fair to say it's below the percentage population." And Madam Clerk said, "Over the last year, yes." So we just want to make it the court clear that we weren't trying to misrepresent anything, but that's the testimony that we're referring to. We made that assertion. And if the court has no further questions, we thank the court for its time.
All right, thank you. Both sides have filed excellent briefs, and they will be very helpful to us in making a decision. We will take this case under advisement. Thank you for participating in the docket, the Zoom docket, and we'll be in recess at this time until 1 o'clock, I believe.
Yes, Your Honor, this honorable court is now in recess until 1 p.m.